I wanted to do a little session on frequently asked questions about interrogatories from the questions that you've sent me. Somebody asked, where do they come from? Well, oftentimes you'll make them up, depending if you're in the Court of Common Pleas and you're seeking less than $50,000, and the case is dealing with either a motor vehicle issue, that is a car crash, or property claims, that is you were walking on someone's property and were injured somehow. Those are restricted to the set of interrogatories that are contained on the Court of Common Pleas website, so you have to use those sets of interrogatories. You can get permission to add more questions, but they're trying to limit some, I guess you'd call it creativity, but there is a set of interrogatories that are often used for those. Otherwise, you make the questions up yourself. Shamikya asked, can you only ask for admissible information? No, you can ask for more than that. You can ask for anything that's reasonably calculated to lead to admissible information. Another question that came up was, can you object to interrogatories? Yes, you can. And there are different ways to do that. You can simply object in your answer and return it to the other side. A more proactive way is to seek something called a protective order, and you do that by motion, be for motion for protective order. Very common. Discovery is at times, judges feel like they're running kindergarten classes. They feel like they're always trying to keep people from haggling with each other about these things, but there's a lot of disputes about discovery, and oftentimes when questions are, if people feel like they're burdensome, if they feel like they're beyond the scope of discovery, if they feel like they're not reasonably calculated to bring about admissible evidence, then you'll find motions to either quash an interrogatory or permit that not to be answered. So that does come up. What else? Oh, a question about the timing of interrogatories. In the discovery process, they're usually first because they're some of the cheapest and they give you information. As I may have said before, everything is always going to lead to depositions. That's kind of the most powerful stuff, and I'll be doing a little video about that shortly. But generally, you'll use the interrogatories so that when the depositions come, which are very expensive, and I think I've told you that already, and I'll spell it out a little more in another video. But the idea is you want to be prepared. You don't want to be fishing around. You want to have some of the information. Additionally, the question that I think led to the most compelling area is Pam had a question about answering interrogatories, and answering interrogatories are a pain, and if this wasn't a video, I'd probably say something even stronger. A running joke would be that there are going to be interrogatories to answer in hell, and the reason is because there's a 30-day time frame. Most people don't always honor that, and oftentimes there are requests for an extension of time for those. And if somebody doesn't give you permission, then they'll sometimes file a motion to compel you to answer them. But answering interrogatories can be challenging, and the reason they can be challenging is because a few things. One, clients aren't always as hopeful as they might be. I think Pam may have asked me, and I think she was on to the way that I've seen it done oftentimes. You receive interrogatories to answer from the other side. Oftentimes, we would make a photocopy of what we'd gotten and forward it to our client and say, we need these back right away. This is important stuff. Doesn't always work. It's not always... The clients don't always act in their best interest, but you need to realize that you need to get this information somehow, and oftentimes your clients are the only people that can help you. I often would try and get clients to buy in. Look, I need your help with this. I don't know the answers to this information, so you need to cooperate with me. There's one thing that comes up sometimes with respect to answering interrogatories, and it's something that I'm going to encourage you to avoid. At the end of the interrogatories that you're going to answer will be something known as a verification. That means, and a verification means that your client will sign something that verifies that the answers provided are true. Oftentimes, in the hurry that you have to get the answers for these things, you will you'll take that sheet and you'll send it to the client, and sometimes you'll ask them to sign it and send it back with the answers that they give you. Then you'll get those answers, you'll complete them, you'll attach that verification that they've given you, and you'll send it to the other side. I think this is a bad practice. I think your client needs to see the very, very, very final draft before you send the interrogatories to the other side. I'm only one person. I've been to many depositions where a client is confronted with an answer to an interrogatory that they gave, and you can tell they have no idea where the answer came from. They don't know the information. Rather, somebody in the attorney's office, the attorney, paralegals, will know the answer and will provide it in the interrogatories that the client returns, maybe editing what the client gave. It's a bad practice because that's embarrassing. Here your client is being asked a question that was in the interrogatories, and now at the deposition they don't know. They're shown the verification and they'll be asked, hey, didn't you sign this? Didn't you say this was true? And the clients will have to say, yeah, I don't know where the answer came from though, and it's just a mess. So that would be my request to you forever and ever and ever. If you have to answer interrogatories, and you will if you work in this field, you want to make sure that the client sees the final draft. In terms of human interaction, there is always misunderstanding, and I would urge you that with respect to complicated legal matters, there's always going to be some misfire. So do that for me, everybody. Make sure that the client sees the final